If you are new to the Kouri Richins case, this is a case out of Utah. It is now 2 separate prosecutions. The trial that is coming up is a homicide trial. Kouri Richins is accused of murdering her husband by poison due to financial stress. If you start going, it's giving Murdaugh. Yes, but she's not a lawyer. She is a boss babe who is trying to flip houses, who does not seem to be doing that very successfully. And we went through the entire new indictment with all of the allegations of mortgage fraud and general scamming. Emily, that's not what it is. No, it's mortgage fraud. It's money laundering. It's literally getting your bestie evicted while stealing allegedly like $50,000 from bestie. There's also an affair, hers, that it comes up because there are text messages back and forth to the paramour, which is how her side piece is referred to in the filings, indicating things like, don't worry, he'll be gone soon and I'll be free by Friday. And then her husband is found dead. She has been trying to pass it off as an accidental overdose, but alas, when there are accidental overdoses, there are often indicia of that around. She has tried to say that they were weed gummies laced with fentanyl. However, her Facebook Messenger messages and text messages and things belie that allegation because she is asking someone to purchase these things for her. And then there is an alleged attempted homicide where her husband becomes very ill after eating a breakfast sandwich on Valentine's Day. He survived that and then was killed by fentanyl, later had 5 times a lethal dose in his system. And then there's the Google searches of like luxury prisons for rich people and can law enforcement find deleted messages and why would the FBI be involved in a case? And if someone dies by poison, what would it say on a death certificate and things like that? And then there were life insurance policies he didn't know were taken out against him, etc. We're going to look at, well, the audacity of one of the subpoenas that's gone out in this case. And then we're going to go to court. This hearing was Monday. We're going to peek in. It's a Zoom hearing. There are going to be a lot of hearings as we get into the new year in this case, as it runs up to trial in February. And there will be a lot of filings between then. My hope with the filings in the Kouri Richins case is to grab all of the filings together. So to do the motion, the opposition, and the reply and kind of do them all at one time, not as they're dripping in, because I know there's going to be a bunch of them. They're going to talk about that in this hearing, I'm sure, because scheduling is a big part of what they're there for. The victim's family lawyer is filing an objection to and a motion to quash a subpoena and for sanctions and a request for a hearing. Comes now, Gregory Skordas, spokesperson for the Eric Richins family, files this motion to quash subpoena under Utah Rule of Civil Procedure 45E and Criminal Procedure 14. They are asking the court to quash in part the subpoena issued by the defense counsel, Kathy Nestor, attorney for Kouri Richins, dated June 23rd, 2025. Impose sanctions and attorney's fees. Like right out of the gate. Refer defense counsel issuing the subpoena to the Utah Office of Professional Conduct for ethical violations. Normally with a motion to quash, it's just like quash the subpoena. This motion to quash is like motion to quash, fuck you and a little bit more of fuck you with a side of, but how dare you? Any other relief that the court deems just and proper. This judge is just so rational, so easy to deal with, and so tempered. He's just going to take a minute. He's not going to just immediately go to sanctions. The attorney first responds to each of the numbered requests in the subpoena as follows. This is what the subpoena is for. Objects to disclosing all emails, letters, text messages, personal or professional correspondence between any employee of the Summit County Attorney's Office, which is request 1A of the subpoena. The basis for the objections to this request are more fully set below. What they are saying is that the defense attorneys for Kouri Richins have subpoenaed the family's civil spokesperson like more of a victim's right attorney, and wants the victim rights attorney's communication with the DA's office. And I imagine if there are any of those communications, they would be, hey, we have a hearing on this day. Hey, the family is welcome to attend this hearing. Hey, it looks like the case is going to get continued because they're making these motions. Hey, this is the process of the case. It would be those kinds of motions. However, Kouri Richins was recently charged with all the additional fraud charges. And some of those are information that the prosecutor's office, I think, likely got from part of the estate settlement stuff and vice versa. But if in trying to deal with probate and settle the estate and the trust, the family came across things that indicate that there might have been fraud, the family can go to law enforcement and be like, here, we think there is additional fraud. We have learned additional things. There's nothing to stop them from doing that. And there's nothing improper about them doing that. You don't get the communications. Also, what's the basis for that in the criminal trial of Kouri Richins? He goes on to say, the attorney, that he never communicated with Detective Jamie Woody and does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1B of the subpoena. Attorney has never communicated with Detective Jeff O'Driscoll, does not have any communications as requested in 1C of the subpoena. Attorney has never communicated with Eric Root. Put an asterisk. I have questions. And does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1D of the subpoena. Skordas, the attorney, has never communicated with any employee of Summit County Sheriff's Office and does not have any communications. And they list it, emails, letters, text, personal, blah, 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 blah. He's allowed to talk to who he wants to talk to. He's the family's representative. Skordas does not have a retainer agreement or engagement letter with any of Eric Richins' family or the Eric Richins Living Trust to provide as requested in 2 of the subpoena. Hey, did they hire you? He could be a family friend. Skordas does not have any checks made payable by the Eric Richins family or the Eric Richins Living Trust as requested in 3 of the subpoena. Mr. Skordas works for the Richins family pro bono.
I'm not even sure the court is aware of this, but we're at 10 terabytes of discovery in this case. It is the largest amount of discovery I've ever had in any case, and I have done complex fraud. They've gone back and found every human being that's ever spoken to Kouri Richins, ever. So the concern is, for example, if they're planning on calling like 15 witnesses that are just to create foundations for pictures, we don't even need them to testify. Like, we'll just agree these pictures are pictures of what the house looked like or what, her childhood home looked like or whatever the heck they're going to put in, and save potentially days and days and days of trial. So we're not doing it to add to their workload unnecessarily. We really are trying to determine, are there witnesses that are being called solely for foundation that we can say, hey, you don't need to do that. If you're calling them to put in, bank records, we agree to the bank records, cancel one less witness. This case has become ridiculous in terms of the amount of evidence. And when I say evidence, I don't mean anything that has anything to do with whether she killed her husband or not. I'm talking about just the universe of prosecuting Kouri Richins has become outrageous. So I guess I don't want it to sound like we're trying to make them give us an unfair advantage. We're trying to eliminate days and days of unnecessary, pointless trial days.
We are at the end of court for a scheduling conference in the Kouri Richins case that was trying to set deadlines, and by the end of court ended up sounding very much like we were back in court in Idaho. But Your Honor, there's 10 terabytes of data. By the end of the hearing, it was, but Your Honor, there's 11 terabytes of data, and asking the prosecution team to narrow down the discovery that will be used at trial prior to their deadlines. And the prosecution said, we will get you what we have. We will get you what we're working on. This case has been continued, but Mr. Bloodworth also at one point said, you all have had the same discovery we have had since you came onto the case, when the prior defense attorney was no longer on the case. So the defense team has had this discovery as long as the prosecution has. The prosecution said, when we get it, we turn it over. And we also took it from not just the cloud drive through Box, but we also provided it on hard drives. You have the discovery. And the defense said, but Your Honor, they're still sending out subpoenas. There's a second case against Kouri Richins with 26 counts. And if the prosecution discovers new things, they can follow up on it. Because if the prosecution discovered something new and didn't follow up on it, there would also be an argument. But Your Honor, they never followed up on this lead, even though it came up before trial or during trial. They needed to follow up on it and they didn't. So the defense is arguing a little bit of a sword and a shield here. And the court did ask the prosecution to work with the defense a bit. And if they had a draft of a drive that had mostly the trial exhibits in it, they would turn it over. But everything is bait stamped. So it is organized sequentially. And then the defense was like, but some things are duplicates. And the court said, so take care of it. And the court said exactly what I said with, hey, if the prosecution started selecting what they turned over and turned over some things and didn't turn over other things, then that would become a problem. Over disclosure, not under disclosure. And the prosecution said they have everything that we have. They have everything within our control. If there are things still outstanding that we do not have yet, we will turn them over when we get them. But then there are 3 different defense attorneys talking in the hearing about different aspects of discovery. And at some point it feels like they just go, but yes, but yes, but yes, and push for just a little bit more, even when the hearing was just about done. However, I will be livid if we see some type of motion to continue. This was set to go to trial in May. It got continued because of the rulings on the motion to change venue. And then it got bumped from May 2025 to February 2026. They should have gotten ready for trial in May. They were close to trial. And the defense is like, but they're just charging her with so many things. Well, you can decide if that's reasonable or not in my videos covering those indictments. So the Kouri Richins case is speeding to trial and to some trial deadlines. We have gone over the civil cases. Those are all now paused. Essentially, they are stayed pending the criminal case. So once the criminal case is done, we will continue to take a look at those. There are some motions in the criminal case we have not gone over yet. We will probably do so in September, October, ahead of those hearings in December, and just take a stream or two and go over all the rest of those motions, because we do have the Donna Adelson case coming up for trial at the end of August. And so we will be shifting focus a little bit to what's been going on in court there. But the Richins case is proceeding normally. People have been working together. The attorneys have largely accommodated one another. The court has been patient and decisive. And I appreciate seeing the more normal aspects of trial where we're not sitting here going, wait, what? Every single hearing. So it's nice to see a case proceeding pretty normally. And yes, a lot of lawyer work is, could this have been an email? And if you're confused about the discovery, why didn't you just send me an email and ask? And Mr. Bloodworth does not seem to be the type of attorney that is going to just ignore you. It seems like he'll tell you what you need to know. And then if he can't tell you yet, he'll tell you he can't tell you. But if they haven't even reached out, Bloodworth said exactly what I was saying. Have they even asked for more funding to get help with the discovery? I don't think they have, because they are conflict counsel. So the defense attorneys are not hired by the public defender's office. They are panel attorneys that are appointed to the case, and they have other trials and what have you. But also everything is being used through a box drive. It seems like it's going to be pretty easy for them to sort. I want to know when we're going to have a hearing on the motion to quash the subpoena between the defense attorney and the victim's family's victim's advocate attorney. That I want to see. So for all of you that are newer to the Kouri Richins case, this is going to be one of the trials we're following. The caveat on that, this judge has forbidden streaming in every prior hearing. Things have been allowed to be recorded and uploaded later. I don't know what the court is going to do when trial starts. So we are going to have to figure it out. I don't want to go to Summit County in February. It will be cold. But we will try to figure out what we are going to do. Hopefully the court will allow a little bit maybe of a stream on delay. I don't know. We have time to figure it out, but the court does not allow it to be streamed in real time. So we're just going to have to wait and see what happens. Maybe the court will change their mind. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.